Hello friends, in continuation of the introduction of the Evidence Act, let us see today what is part 1, chapter 1. Chapter 1 has got 4 sections. First section deals with short title. This act may be called as Indian Evidence Act 1872. Then extend. This act is extend to whole of India in all judicial proceedings, including Army Act, Naval Act and Air Force Act. And section 3, interpretation clause. Interpretation means what is that a term will be conjuncted with another term in order to draw an interpretation of conclusion. That is why this interpretation clause has been given exclusively in the Evidence Act. In this court, the court includes all judges, magistrates and the persons except arbitrators legally authorized to take evidence. Fact. Fact means and includes anything which may be in the form of a physical mass. Take example, a static stone, a granite stone which might have been used in commissioning an offense, or a car, a thing which is not a person. Then state of things, what is in which the state of the thing is available, what is the state of that thing, whether it is a moving thing or a static thing, it has to be taken into consideration. Then, or relation of things, what is the relation between two things if they are forming in a fact? Then capable of being perceived by the senses. For example, if we touch with our hands, we should be capable of perceiving those things. Can be seen, read under subclause 1 of clause fact, that these are the things. The second thing is, second part, point number 2, any mental condition of which any person is conscious. Any mental condition, maybe he is mentally unsound, maybe he is not mentally unsound, or whenever a person who is in consciousness, that person can be treated that it is a fact. Why it is so relevant in respect of, very importantly referred in this is, for example, a person is about to die, male or female, or a person who is about to die got admitted into the hospital. Maybe there was a murder attempt or committed of suicide, or whatever the reasons may be assigned by the police. Or if at any point of time, if it happened to write that person's dying declaration under this act in section 32, while writing the dying declaration, the mental state has to be mentioned. Whether there are any persons surrounding him influencing to give a statement, or the person who is unconscious, and what is that the conscious of mental state basing on which he is giving a statement has to be considered, and that has to be treated in the form of mental condition. Now let us see. Relevant. One fact is said to be relevant to another when the one is connected with the another in any of the ways referred to the provisions of this act relating to the relevancy of facts. Suppose if we are talking in respect of a house, some theft has been committed. Suppose if a particular fixed fixture is extracted from that house, will be a relevant fact in order to discuss about relevancy of facts. Then facts in issue. This is very important in order to know the evidence, not only Evidence Act, for every proceeding, every suit, every litigation, this is most important. The expression fact in issue means and includes any fact from which, either by itself or in connection with other facts, the existence, non-existence, nature of extent of any right, liability or disability asserted or denied in any suit or proceeding necessary follows. So the fact which has to be determined by a court of law will become an issue to be decided. Whatever the facts which will be submitted from either the person claiming it or the person denying it, or some other persons, those who have right over the property or otherwise, or persons making in a collective form of complaint or otherwise, these facts will be placed before a court of law which is dealing with either civil or criminal, will have to evaluate the facts, frame an issue and decide it accordingly. Next, document. Document means any matter expressed or described upon any substance by means of letters, figures or marks, or by any other than those means intended to be used or which may be used for the purpose of the recording that matter. The document means that anything which is written, suppose a single straight line has been written, a test has been come before the court that it was asserted that a person wrote that straight line with his right hand, if there is no right hand. So the document includes everything, including pictures, which are making part in respect of deciding the fact which will be framed in the issue. Now let us see evidence. Evidence means and includes all statements which in the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry. Such statements are called oral evidence. Any evidence which is given in the course of the trial will be called as a oral evidence. Such documents are all called documentary evidence. Proved. A fact is said to be proved when, after considering the matters before it, the court either believe it to exist or consider its existence so probable that a prudent man ought, under the circumstances of particular case, to act upon the supposition of that fact exists. Suppose if one particular property or one particular incident, it appears and it is before the court, it need not be proved that that itself is in dispute. That is called proved. Disproved. A fact is said to be disproved when, after considering the matters before it, the court either believes that it does not exist or considered its non-existence so probable that a prudent man may believe it. According to this, when we see this thing disproved, why court may have to think in respect of disproved? Suppose in any suit or proceeding, if a property is a sale deed, a registered sale deed, which is covered by Section 79 of Indian Evidence Act, that it is a certified copy issued by a particular authority, that is presumed to be original. If that copy itself is in question and the land in question may be right, but if the boundaries doesn't tally with that of the boundaries which are existing, it is almost disproved. Therefore, every litigation, what is proved, what is disproved, what is conclusive proof, what is proof, has to be thoroughly scrutinized even before initiating a litigation. Not proved. A fact is said not to be proved when it is neither proved nor disproved. If the fact which is placed either by the party before the court of law, it is not proved it is neither disproved. Therefore, it can be clearly concluded that it is not proved. And India means the whole of the India, what we discussed in the extent. May presume, section 4, may presume when it is provided by this act that the court may presume a fact, it may either regard such a fact as proved unless and until it is disproved, or may call upon proof of it. This has a little understanding. May presume. Suppose if I have asserted something against the other person has not disputed in respect to my allegation or assertion. Therefore, once if it is not in dispute, that may be presumed by the court. Shall presume. Whenever it is directed by this court that the court shall presume a fact, it shall regard such fact as proved until it is disproved. Shall presume means it is already placed before the court shall presume. That means it is not discretionary, it is mandatory. Unless it is proved that it is not in existence, then it comes to the picture. Then conclusive proof. When one fact is declared by this act to be conclusive proof of another, the court shall, on proof of the fact, regard the other provided and shall not allow evidence to be given for the purpose of the disproving it. When there is a conclusive proof, let us take for example a dead body after the conducting of post-mortem examination, that is a conclusive proof. That cannot be called for again that the body is dead or partially dead. Therefore, with this, today we are completing. We will meet with another chapter in the next session. Thank you.